Hi, everyone. Thanks for joining us today. I'm Owen Davis, a labor and employment attorney in our Denver office, currently broadcasting from Washington, D.C. Thanks for joining, and welcome to our annual Colorado Labor and Employment Legal Update. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the question box. We will try to answer all your questions during the webcast today, but if a more complete answer is needed, or if we run out of time, we will try to answer your question later via email. A PDF of the presentation is available in the Program Materials folder. This program has been approved for legal education hours. For live attendees, report your hours by clicking the CEU icon at the bottom of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your organization's needs. That's all for housekeeping items. Let's get started with our program. There are 4 sections we'll be covering today. Please be sure to take a break as needed, as we won't have any formal breaks within the program. First up, we have Ashley Jordan and Molly Callender-Hobbs covering family and medical leave insurance. Over to you, Ashley and Molly.
Good morning. My name is Ashley Jordan. I'm a partner in the Denver office of Husch Blackwell, and I'm so pleased to have Molly Hobbs up here with me. We're both partners in the employment group, and I traditionally practice in the space of consulting and litigating employment issues, and Molly is a frequent collaborator with me because I turn to her quite often for employee benefits issues, and she is a specialist in that field. And so the two of us together are going to discuss FAMLI today. If you're a regular at our seminars, you may recall that I've talked about FAMLI a couple of times before. This has been one of those programs that's been in the works for a few years. I've traditionally said it's just something to keep on your radar. You don't really need to do anything right now. We have more questions and answers, but we're at the point now where there's actually some to-do items for employers, and we want to make sure you know about those. And we actually have gotten some more guidance from the Colorado Department of Labor, and we want to share all of those updates with you. So I'm not going to spend a lot of time on what FAMLI is, because I'm hoping that it's not a new concept to you and that you've at least heard of it before. But just very, very generally, it's a partial wage replacement for employees, and it provides either 12 or 16 weeks of partial wages to employees. The idea is that employees can take some time off for certain circumstances and get paid at least partially while they're out. And it also frees up some money for employers who are dealing with employees taking that time off. So for example, if an employer finds out that an employee is going to be out for 12 or 16 weeks under FAMLI, then that employer might choose to use the wages that would otherwise be paid to that employee for overtime for another current employee who's not taking leave, or maybe a temp worker or something like that. So that's kind of like the, where it came from and what the purpose of it is. There are a couple of reference points for you all that if you want to kind of learn more about the background and just kind of what the statute actually says, I've included the Colorado Revised Statute number for you. I have to say, it's not full of a lot of legalese, so it's pretty easy read. It might not be your most interesting read, but it is pretty straightforward. But most importantly is the website, and that is something that will become your best friend if you're dealing with FAMLI. Just preparing for this presentation today, I know Molly and I both consulted it numerous times. It's pretty helpful. One of the things that I like about it is that it has a tab for past webinars. So even if there's obviously notifications of upcoming webinars, but it also has copies of past webinars where you can see specific topics that have been discussed. You can see the past newsletters that have gone out. There's an employer toolkit that's pretty helpful. And so I have found that personally to be very helpful in terms of having questions answered. There are actually dedicated Q&A sections on that website. So that will be something that I would recommend that you spend some time on if this is going to be something in your wheelhouse, meaning family, if that's going to be something that you're in charge of at your place of employment. So where are we? You know, we're kind of still in the education phase and making sure everybody kind of knows what's going on, but we have some real deadlines coming up. And the first one is in about 3 months, and that's when payments are going to begin. So premium collection is going to be happening. There's a new FAMLI, I keep saying FAMLI sometimes, but it's actually FAMLI. It's FAMLI division of the Colorado Department of Labor. They're going to be the ones that collect the premiums. And importantly, the benefits are not available starting in a few months. They're going to be available to employees a year and 3 months from now. So there will be a full year of premium collection, and then the benefits will start after that. Now, you're probably thinking, oh, wow, like, can anybody take time off and take family and have their job protected? And the answer is no. There are certain events that give rise to family benefits. And at first glance, you might say, wow, that looks kind of similar to FMLA. There are some similarities. At first glance, it might look like they're pretty identical. They're not. And we're going to go through some of those nuances throughout this presentation. But this gives you an idea of what events do give rise so that you kind of are put on notice. And unlike FMLA, they would actually get paid at least partially for that time off. Okay, so next we have who is a covered individual. And again, the statute goes into a lot of detail on this. I just wanted to point out, family is a lot less stringent than FMLA. So almost, well, I shouldn't say almost all employees, but a lot more employees will be covered under family than would be covered by FMLA. The thresholds are just a lot lower, but at the outset, you may be wondering, well, does that mean that family doesn't even apply to me in certain circumstances? Family is available, and employers need to be complying with it as long as you have one employee or more. So that's all it takes. One employee working substantially in Colorado. If you have less than 10 employees, however, you are not required to contribute part of the premium. You can put all of that burden on the employee. And so you might be wondering, I've forgotten what the premium is. So I'll just go ahead and tell you, it's 0.9% of an employee's total compensation. So if you're splitting it evenly, which is going to be any employer with 10 and more employees, it's going to be 0.45% each. Now, the employer with the small number of employees, they don't have to contribute, like I just said, but they could. They could, as a perk, say, we're going to go ahead and contribute half just to be nice, or, you know, as an added bonus or benefit, but they do not have to. And so just want to make sure, again, you might look at this and say, oh, I kind of remember some thresholds for FMLA. They look pretty similar. They're definitely not. And so that's just, again, a difference between the two that you want to make sure that you understand. Now, one of the main reasons that I had Molly join is that there is something called a private plan exemption. And so this may apply to you, and I want to make sure you can take advantage of it. And so I'm going to let her go ahead and explain what that is under this statute.
Thanks, Ashley. So as Ashley mentioned, my specialty is employee benefits and compensation. So this private plan exemption to the family leave program is of particular interest to me because I work with a lot of employers on crafting their individual benefit programs. So probably the biggest thing with respect to the family division is that employers can satisfy their family obligations by offering an equivalent private plan. I think there's two big takeaways here. The first one is that Colorado's been a little bit slow on the uptake. So regardless of whether an employer intends to lean into the private plan exemption or not, all employers are still going to have to start making premium contributions on January 1st, 2023. So if you are an employer that is thinking you want to use a private plan, you still need to be prepared to start taking those deductions on January 1st of this coming year. I think the second thing that is important to remember here is that it is an equivalent private plan exemption. So I think there might be employers out there thinking, well, we've got a short-term disability policy, we're in good shape. And that very well might be the case. It may not be the case. So when the state is saying that you need an equivalent private plan, that means you need to be looking at the number of weeks of benefits, the level of wage replacement. Are you applying any additional eligibility requirements or conditions? You can't deduct any more from your employees' paychecks than what is allowed under the state laws. And you're going to have to cover all of your employees. So, for example, an employer that is thinking, well, I'm going to put in place the Cadillac of private plans for my executive team, and then everybody else is just going to participate in the family plan. That is problematic under these laws. And I think the other important thing here is that we have some new, very, very new proposed rules that just came out. So Ashley and I think we've reserved basically the remainder of our presentation to do kind of a back and forth Q&A because, as we've mentioned, our practice areas are different. So, so I had a lot of questions where I'm coming to Ashley and asking questions, and she's coming back to me. We've also received a lot of questions from our clients, so we wanted to incorporate those into the presentation. So without further ado, we are moving to Q&As. So the first question we kind of just did a high-level outline of Q&As rather than including all of them. So my first question is for Ashley. Ashley, how often are contributions made to the family division?
Okay, and I do get this question a lot. People are trying to understand, especially from a burden standpoint, how often they're going to be dealing with this. So obviously deductions will be taken out of each employee's paycheck, and it should be noted on the pay stub. But in terms of submitting the premiums, that's going to be quarterly. It's going to be pretty similar to how unemployment insurance works. There should be an online portal. I say should be because it's not in place yet. But the hope is that, by January of 2023, it'll be up and running, and that's how you would submit the premiums, and it's going to be on a quarterly basis.
Got it. And then I'm curious, does the employer have to notify employees about their ability to utilize family benefits?
So that's another question of how do we roll this out and who needs to be informed of what? And so if you don't get everything out of this presentation, that's one of the things that I hope that you'll walk away with, because there are some very true to-do items that need to happen, and they're the employer's obligation, definitely. It's the burden is on the employer to make sure that employees understand and know that this is going on. So first, there's a poster, and it's actually on the FAMLI website, but we've also included it in the resources link that's part of this webinar so that you don't have to go searching for it. It's pretty easy to get. And it needs to be posted in a prominent place. And so I would recommend in a break room and a lunch room, something like that. If your workforce is remote, then I'm hoping that you would put it on your intranet. I mean, the bottom line is it has to be somewhere where employees will see it and that they can go back and see it. They don't just see it once and then it disappears, but somewhere where they can go to and really read it and refresh their memory upon it or on it upon a qualifying event. So in addition to the poster, we also have a requirement that for all new employees, notice needs to be required that FAMLI exists and that employees can take advantage of it. So it does, the statute does say newly hired employees, so that doesn't necessarily mean you have to go back to all the other employees, but you really should do that as well, so that everyone knows that this is happening, that they can take advantage of it. And frankly, it's hopefully going to be a perk to employees realizing that they have a benefit that they didn't used to have, and it'll make them appreciative of this new program and the fact that they can get paid at least partially while they're out on leave for a significant event. And then finally, I just want to make sure that you know that when an employee comes to you, and it's probably going to be an HR individual or it might be a manager, that if the employee starts talking about, I need to be off, I've got something going on, they don't have to use buzzwords. They don't need to say, I'm a covered individual and I want to implement family benefits. They don't have to say that. But if they say they need to take time off and that it's for a reason that would fall under a family, then it's the employer's responsibility to remind them of the benefit and tell them to apply for those benefits, because they would apply for it through the state, and they need to be directed to the website, which would have directions for the employee on what to do. So it is kind of a lot on the employer, but it's really mostly at the outset, and once it's actually in place, and it's pretty straightforward.
Interesting. Now, not to dive too far into acronyms here, but how do FMLA and FAMLI interact? Okay,
so first of all, you're right. FMLA and FAMLI, people get them mixed up all the time. They look similar. There are some similarities between them as programs or acts. I'd say I want to get to the differences is your question, and that is something that I get asked about quite a bit. Both of them, just making sure everyone understands, both of them require that an employee gets job protection. So when they're out on leave, they are protected unless there's some kind of narrow circumstance, but generally they should be coming back to the same or a similar, substantially similar position. Now, there are lots of differences, and that's why you really need to look at the resources or reach out to us or something like that, because you don't want to make a mistake here. At the outset, FMLA is unpaid leave. FAMLI is paid leave. It's not full paid, but it's a partial wage replacement. It's capped at $1,100 per week. Again, FMLA is to a max of 12 weeks. FAMLI is either 12 weeks, but it could go up to 16 weeks under certain circumstances. And I think just overall, I would just say an employee may not be eligible for FMLA leave, but it's going to be a lot easier for them to be eligible for FAMLI. It's just lower thresholds all the way around. So for example, with FMLA, you need a 50 employee count threshold. That's not needed for FAMLI. The employee doesn't have to have worked at the place of employment as long to be eligible for FAMLI compared to FMLA. So again, they're kind of picky, but when you're running into that, you want to make sure you understand that just because you're not eligible, the employee is not eligible for FMLA, does not mean that they wouldn't be eligible for FAMLI. It's actually often can be the opposite. This is reminding me one thing that I want to also make sure everyone understands. You may be kind of cringing right now. Oh, wow. Can an employee actually take 12 weeks of FMLA and then take another 12 weeks or maybe even 16 weeks of FAMLI? The answer is no. But the burden's on you, the employer, to ensure that when applicable, that the leave is designated as both so that they run concurrently. If you don't do that, then there could be some argument that they should run consecutively, but that's not required. And that's definitely not something that you want.
I would agree. So what about FAMLI's interaction with other leave programs?
So I will admit this is tricky. So you've got traditionally paid time off policies that might be in the form of sick leave. It could be vacation leave. It could be, just PTO for any general purpose. You could have a collective bargaining agreement. You could have employer policies or an employment contract. You could have short-term or long-term disability. You could have the ADA, the FMLA, HIFWA. I mean, there's a long list. I think that we could do an entire seminar just on that. So suffice it to say, I do want everybody who's listening to be careful. Just because you have FAMLI does not mean that changes are made to your other existing programs. In fact, it's usually the opposite. Let me just look at my notes because there were a couple of things I wanted to make sure that I covered. Okay, and one of them is that an employer absolutely cannot require that you take paid time off first and then get FAMLI. That is against what the statute says, and it's very specific. So you as the employer cannot tell the employee, oh, I see you have a month off that you've accrued over the last few years and it's carried over. And so if you want time off under FAMLI, you really need to take your sick time first, or you need to take your vacation time. Absolutely not. That's not allowed. You have to allow both. What employers also need to know is they need to decide now how they want to handle this partial wage replacement. So for example, the employee gets, like I said, it's capped at $1,100 a week. What the employer can do, but doesn't have to do, but you need to decide now and make it part of your policy. Do you want to allow your employee to use PTO, if they have any, to make up the difference? That is allowed. What's not allowed, and you might get this from the employee, is that the employee can be made whole, but the employee can't be made more than whole. So the employee can't get full-time PTO plus the FAMLI benefits. It would just be partial PTO to make up for that difference. One other note that I want to make is that short-term and long-term disability programs can run concurrently with FAMLI, but it's up to the employer to provide written notice to employees of the requirement if they're going to run concurrently. So again, it's allowed. It's all about notice and making sure that you have the documentation to support it, that you're alerting employees of what your policy is, and that you have this in written form so you have something to refer to so that there's not confusion later. A couple other, when I was going through my litany of what else could be at play here, we also have workers' compensation. We also have the ADA. Again, these all they interplay together. Many of them can operate together, but it is confusing. So I would say if you're dealing with those situations, that's pretty sophisticated stuff, at least for now, while we're waiting for even more guidance. And so you might want to reach out so that we can help you with that.
Thank you.
Yeah, so I have answered a lot of questions. I think it's only fair that I ask Molly some questions. And these are ones that I traditionally punt to her when I get them. Whenever the word private plan is part of the question, I say, oh, I have just the person for you, and this is what she specializes in. So I just picked a few that I've gotten recently that I've asked Molly so that she could answer them. And what we figure is that if one client has reached out, then maybe a bunch of you are wondering the same thing. So we want to share the knowledge. So Molly, is there a place to purchase a FAMLI compliant equivalent of a private plan?
Currently, no. So again, as I mentioned earlier, Colorado has been a little bit slow on the uptake with respect to private plans. So apparently there is intention to bring some sort of marketplace where employers would be able to go and kind of shop through insured products that would be FAMLI compliant and also be a private plan. But at this point in time, that marketplace does not exist. So essentially stay tuned. The timeline they're giving currently is between Q1 and Q3 of next year.
Okay, so it could be another year from now.
Correct.
Okay. All right, next question. Does a private plan have to be an insurance policy, or could the employer self-insure, such as manage the program in-house?
Yeah, so that's, and the answer is you can do both. So, so again, Colorado is rolling out a marketplace apparently where you can go and shop for insured products. An employer, many employers, I think, already do, similar short-term disability is frequently done on a self-funded basis. So I don't think it's uncommon to think of kind of this type of benefit in that framework. So employers are still definitely allowed to self-insure this type of benefit.
Okay. And one I know I've gotten very recently. So how does an employer even go about applying for a private plan exemption? What do I need to do?
That's a great question. And actually, up until very recently, the answer was, we don't know. Fortunately, we very recently got some proposed rules from the state. So again, these are proposed, these are not written in stone, but they at least give us some idea of where, what the state is thinking. So at this point in time, we know that there is going to be some sort of application form. We don't know specifically what that looks like, but obviously we'll include information about the employer. Almost guaranteed you're going to have to include a copy of your plan document. And there's an attestation that you understand and comply with the FAMLI Act. In addition to that, you are going to have to pay a $1,200 application fee to have your private plan reviewed by the state. Additionally, if you are intending to self-insure or self-fund this benefit, there are a couple of other hoops you're going to have to jump through. Specifically, you're going to have a surety bond that you're going to have to present to the state to let the state know that you are in fact financially stable. And the other piece that you're going to have is a separate account. You're going to have to you need to set up a separate account where all of your contributions are going to live for this benefit. Again, for those of you that are familiar with self-insured or self-funded plans, the concept is always that those benefits are coming out of the general assets of the employer. And that's still accurate. In this scenario, it just means that you kind of have to have a separate bucket where all of this lives. And one more piece that I think is important here, because as I mentioned earlier, whether you intend to use the state-provided program or whether you intend to use a private program, either way, you are going to start paying premiums on January 1st of 2023. So I think a question that we're getting a lot is, well, if we're going to use a private program, do we get those premiums back? And the answer is yes. So you will be refunded on those premiums that you pay in 2023 if you get your private plan approved. There is currently a deadline, so essentially you would need to apply for your private, and I think be approved for your private plan by October 31st of 2023. So essentially you have a 1-year timeline.
Okay, that's helpful. Here's another one. If an employer is granted a private plan exemption, when does the plan become effective? And does it expire at some point?
Yes. So if you apply for the private plan exemption, there is essentially your plan is going to become effective if you are granted the exemption is the first day of the second calendar quarter. So I guess to provide an example, if you are applying in September and you are approved in September, that means that your plan would be effective January 1st. So you've got a little bit of lag time between the approval and when the actual effective date begins. I have a couple notes on this one. It's important to remember that even if you get an approval, you're still going to have to continue withholding premiums for the FAMLI program until the effective date. So again, using my example, if you're approved in September, your effective date isn't until January 1st. So in that buffer period, you're still going to have to continue withholding premiums for the FAMLI program during that period of time. Secondly, if you are approved for a private plan, there is an additional notice that you will have to send to all of your employees explaining that you are using a private plan instead of using the FAMLI program. So notices left and right, basically. In terms of expiration, yeah. So if you get a private plan exemption, it lasts approximately, at this point in time, under the proposed rules, they're saying it's going to be a 2-year cycle. So you would have that exemption for 2 years, and then you would have to reapply for another 2 years. There is kind of a run out on that. So apparently if you get granted 2 consecutive 2-year periods, then you might be able to get a longer period where you don't have to continue applying. But again, the rules are proposed, so we aren't totally clear on that piece yet.
All right, I think we have time for one more question, quickly. If an employer is granted a private plan exemption, does the employer have any continued obligations with respect to the FAMLI division?
The answer to that is yes and no. So an employer is not going to have to submit premiums or wage reports to the FAMLI division, but the FAMLI division is definitively still keeping tabs on you. So there's basically 4 areas that there's currently under these proposed rules that there would be interaction with the FAMLI division. There are record keeping requirements. There's an annual reporting requirement. There's an audit possibility, which is not uncommon. So the FAMLI division reserves its right to audit those plans. And there's also some kind of interesting nuance with the appeals procedure that if the employer denies an employee's benefit under a private plan, that employee could actually appeal to the state. If the state comes down and reverses the employer's decision, then actually the employer says, well, we're still not going to pay it. There's some pretty aggressive looking fines. So, so that's something to note. And we're talking kind of in the range of hundreds of dollars per day. So, yeah, if the state tells you you need to pay a benefit, you should pay it.
Great, thank you. So we're running out of time, but I do want to let you know that we've included 2 slides that start here, and they'll be you'll get a copy of the written materials so that you have something to refer back to. These are the steps that we think that you need to be taking right now, or at least be thinking about. They're pretty straightforward. And some of them have some somewhat time-sensitive deadlines, like I said before. January 1st of 2023 is a big one. But I think right now what you want to do is internally make sure you understand FAMLI, go ahead and register, figure out your premiums and who's going to be handling that, and make sure that the payroll deduction is ready to start in 3 months. Think about all the things that Molly said, whether or not you want to try to go with a private plan or not. And then you want to start giving notice. You want to provide notification to the employees. You want to put up the poster. You want to change your new employee packet or orientation materials, and do some training. I know that Shauna Ritz, who's in our office, she's going to be talking about written policies and handbook updates. So she's going to be touching on some of these things. And so I'm going to let her take it from here on that. We are here to answer questions, so please let us know if you have any. The only other thing I have is that we included the FAMLI with other leaves in a 3-page chart, just as a reference point for you all. We're not going to go through it, but it's on the Colorado Department of Labor website. And when we saw it, we thought it was pretty helpful. So we've included it there for you. And thanks again. Owen, we'll let you take it from here.
Thanks, Ashley and Molly. That was great. I really enjoyed the Q&A section, especially. And I know that's a really complicated topic, and it's only made more so by the fact that we're still waiting for so much guidance. But I appreciate that overview. Before we get to our next presenter, we have our first poll question for the day. This one will help us learn a little bit more about you all that are in attendance. So the question is, what best describes your role within your organization? Human resources representative, executive manager role, in-house counsel, or our favorite catch-all, other? I'll give everyone some time to answer. Looks like we still have a few responses rolling in. So here we go. So unsurprisingly, I'd say we have a lot of people from HR here, but there's also a good mix of in-house counsel and executive manager role representatives. Great. So we'll move on to our next presenters now. Next up, we have Barbara Granjean and Sonia Ramirez Anderson covering equal pay, pay transparency, new unemployment requirements, and amendments to the Colorado Anti-Discrimination Act. Take it away, Barb. Take it away, Barb and Sonia.
Like Owen said, my name is Sonia Ramirez Anderson, and I'm joined here by our office managing partner, Barb Granjean. And we're going to talk to you today about some of the changes that Colorado has implemented regarding their employment laws, and particularly changes that Barb and I have identified as being really important for you as employers to know about. We're going to talk about different changes. The first set of changes I'm going to cover, those are going to be three topics. The first is going to be, as you see here, the changes to Colorado's unemployment insurance notice requirements. The second topic will be changes to the Colorado Anti-Discrimination Act, and I'll end my portion up with changes to the Colorado Whistleblower Act and workplace safety issues. And then I'll kick it over to Barb to give you a really great in-depth discussion of equal pay for equal work and the changes that the CDOL has had for that one. So for the Colorado Unemployment Insurance Act, currently all employers are required to provide notice to their employees that unemployment benefits may be available to them upon separation. What changed in May of 2020 is that now the employers have an additional responsibility. That additional responsibility is what you see in front of you, is this form that the Colorado Department of Labor posted just yesterday. So this is very much fresh off the press for you. And you'll see here that I have circled at the bottom portion of the page, the piece of information that we have identified as being most important for you as employers to take a look at. And this slide here allows you to look at this a little bit closer, and you'll see that there are 4 different pieces of information that employers are now required to provide. The first one there is if the employee quit, you provide the reason the employee quit. If there's a layoff, you check that second box. The third box, which is going to be the most important box, is the discharge box, and you must provide the reason for discharge at the time of separation. And then the last box is other. So the reason that we have identified this third box as the most important box is because of the potential to create a whirlwind of litigation for employers if the employee decides to file a charge of discrimination against the employer. And what I mean by that is, in the event that an employee is fired from their job, and being the great employers you are, you know that you have to fill out this new form. Whoever is filling out the form gets to this bottom part of this form and does their due diligence, checks with the supervisor to see why that employee was discharged. And the supervisor, in a rush to get out the door, says, oh, this employee hasn't been here for 15 days. So per our policy that I'm sure your Husch Blackwell attorneys drafted, that's an automatic job abandonment and termination. So the HR professional fills out this third box and says job abandonment and provides it to the employee fully completed at the separation meeting. 300 days later, the employee decides to file a charge of discrimination with the Colorado Civil Rights Division. You again turn to your favorite Husch Blackwell attorney and say, hey, we have this charge of discrimination. Will you handle it for us? So upon receiving that charge, we do our due diligence and we interview that supervisor, and we find out that not only did the employee abandon their job, but equally important to the supervisor, that employee had substantial work performance issues. And that was a contributing factor to the decision for termination. So what has now happened is that we have potentially 2 different conflicting reasons for termination, and meaning that the insurance notice form has job abandonment as the reason, but now our position statement might have to include poor work performance. And so what this does is it sends a red flag to our Colorado Civil Rights Division investigators that something else might be going on. And so that just creates a new battle or a new hill for employers to push back on and really explain why there might be a discrepancy here. The other equally important information that just came out yesterday is that employers not only have to provide this form completely filled out, but they have to provide the form both in paper, so at the discharge meeting, and electronically. And this is something that, Barb, you've already seen questions on, and about how are we going to provide this completed form to our employees when they don't work for us anymore. And Barb had a great, provided some great insight. And so her piece of information is you're going to have to send it completely completed to the employee's personal email address. What if the employee doesn't have a personal email address? We're not sure yet. But for right now, what we're advising is send it via email so that way it's compliant with this new employment law requirement. Next, we're going to...
So do you mind, Sonia, if I clarify just a timing issue? I think this law required employers to provide this information starting in May of 2022. Is that right?
Yes.
Okay. And then it's this form. Now we finally have the official form. But employers should have been providing this information between May of 2022 and now on their own form. Is that right?
Yes, okay. That is right. So thank you for making that distinction. So that's why the Colorado Department of Labor promised us back in May that they would have a model form to provide to our employees. And yesterday is when they, at 4 o'clock, as sometimes we do things, provided this form. So next, I'm going to talk about the Colorado Anti-Discrimination Act. And as we all know, the Colorado Anti-Discrimination Act protects employees based on certain categories of protected classes from discrimination. And so there's been a really important change to that law. And here we have a quote for the notorious B.I.G. And the change to the law is that now employees can bring an age discrimination claim and seek punitive or compensatory damages. And the reason this is a big deal is because previously, if an employee brought a charge of discrimination based solely on age, the business risk assessment of that claim was that this is probably not going to be a high dollar claim because that employee is not going to be able to access punitive or compensatory damages unless they had an additional claim such as race or sex-based discrimination. So the reason that this is important for you all to know is that you're going to see your age discrimination cases come with a different kind of risk assessment. So it's important for you as employers and HR professionals to let the business know that they're going to see probably an uptick in the amount of risk that your Husch Blackwell employees are assessing for age discrimination cases where they usually didn't. So that means that sometimes settlement requests might be higher or things like that. So, and they might get some sticker shock value. So just give them a heads up that this is why now these age discrimination cases are going to have a higher risk assessment. So here we have the rabbit from Alice in Wonderland, and Rabbit was fired, and they realized that today was 300 days from the day that they were fired. And so now they are racing to the Colorado Civil Rights Division to file a charge of discrimination. As we all know, the employees already had 180 days to file a charge of discrimination. The Colorado Civil Rights Division has just said, you know what, we're just going to give them 300 days. And so the reason that we've identified this as something that's significant for employers is because now employees or former employees, they just have more time. They can go use that time to consult their favorite plaintiff's attorney. And so the second part of that is it just creates a bigger hassle for you as employers because you're already dealing with passage of time. You were already dealing with a 6-month lag, meaning that when we're doing our witness investigations, people's memories lapse. Something that they remembered, fresh the next day after discharge, they're going to forget. And so our advice to our employers is to just really be meticulous about making documentation regarding the reasons for discharge. And these are all best practices we've already told you to do. So we just want to make sure that we're a kind reminder to continue to do that. Speaking of time, the Colorado Civil Rights Division is really overwhelmed with all of the new claims that are coming around based on Colorado's new laws. And so now one of the administrative changes that the Colorado Department of Labor has made is that previously the commission had 270 days to determine if they were going to issue a hearing on a charge of discrimination or if they were going to give up jurisdiction. The administrative piece to that was that the parties could request an extension of time based on good cause. So now the CCRD, or the Colorado Department of Labor, has just cut out that middle requirement, and they're just going to give all of the Colorado Rights Division investigators 450 days total to decide if they are going to take up the case and set a hearing for it, or if they're going to give up jurisdiction. So the end result is that maybe the CCRD will see a decrease in their backlog, and we can start getting some right to sue notices quicker so we can close cases faster. The next change to the Colorado Anti-Discrimination Act is really something that we're just flagging for you for future purposes. As you know, Colorado has recently seen a wave of legislature aimed at protecting employees against discrimination based on their sex. And so here we have a unique instance in which the legislature has decided to provide a carve-out for employers who want to take sex into consideration when hiring childcare domestic employees. And so the reason that I flagged this for you all is that now we know that the legislature knows how to make carve-outs for instances in which they feel that sex really does play a part in the end work product. And so here's an example of when that has happened. And so what this means for employers, it might mean that we might start seeing more carve-outs for the under the Colorado Anti-Discrimination Act. We don't know. We'll have to wait and see. And so my final topic, we're going to talk about the Whistleblower Act and general workplace safety changes. The first one is that in 2020, when the pandemic was at its height, the Colorado Department of Labor issued a law that permitted employees to bring claims regarding workplace safety surrounding the COVID-19 pandemic. And they made that a protected activity, meaning that employers could not retaliate against those employees for making claims about the COVID-19 pandemic. What this new law does is it really expands the breadth of that whistleblower law. And what I mean by that is now they've removed the caveat that it has to be related to the COVID-19 pandemic. And more importantly, employees only have to make a claim that they have reasonable belief that a violation occurred. So this is an example of that. Say you're working at Alice in Wonderland factory and your employee says, we're supposed to wear gloves all day. They have to be white gloves. And this is a Colorado law. And you being educated from our webinars know that this is not a Colorado employment law requirement. And so you hear the complaint and then ultimately say, okay, there's nothing to do there. We're not going to investigate it. 2 weeks later, that employee shows up really drunk to work, and the supervisor, based on the training we've given them, has figured out that this employee is drunk. And so your Husch Blackwell prepared zero drug and alcohol policy says that if you show up for work drunk, you're automatically discharged. So you, as the supervisor, start that process to discharge, and then now what we're recommending is that you take into consideration that that individual has just engaged in protected activity 2 weeks prior. And so now we're not saying you can't go ahead and discharge that employee, but you just want to make sure that you are documenting the reasons for discharge, and that you might even want to consider severance because of that protected activity. And so the next issue that we're going to talk about is the battle of the masks. So Colorado now has a law that permits employees to bring their own mask. So for example, if an employee says because of their religion, they cannot wear a face covering that covers their mouth, now in Colorado, that employee is permitted to bring their own mask, and that could be a clear mask or any kind of other mask that they want to do. Maybe they just want to be really fashionable. And then I got one more slide. So after we consider masks, now anytime that employee now that employee is no longer with the company, you remember that you have a non-disclosure agreement with that employee. You remind that employee, hey, you can't talk about any workplace safety health violations you think happened. That's no longer permissible in Colorado. The non-disclosure agreements need to carve out space for workplace safety. And the key piece here is if it does not, then the courts will render the entire non-disclosure agreement void and unenforceable. They're no longer going to blue pencil it and carve out a specific piece. And I'll round it off with, there's this lovely new notice that you're required to post in your workplace, or if your employee is a remote employee, then you have to provide this poster within the first month of employment. And with that, I'm going to change it over to Barb, and she's going to talk about the Equal Pay Act. Thanks, Barb.
Thank you, Sonia. Good stuff. Okay, well, the Equal Pay for the Equal Work Act. You've heard me talk about this before. This is the law that Governor Polis signed into law in 2019, and it had an effective date of January 1st of 2021. We are coming up on the 2-year anniversary of this law, and I will explain shortly why that's important. So just a refresher on the equal pay portion of it. It's not actually equal pay for equal work. It's equal pay for substantially similar work. If there is a pay disparity for people doing substantially similar work, then it needs to be explained by one of the specific statutory exemptions listed here on the slide. And what's important to remember, and I've stressed this before, is there is no catch-all exemption for any other legitimate business-related reason. It has to fit into one of these specific statutory exemptions. So what's new with the equal pay portion of the Equal Pay for Equal Work Act? Well, not really anything yet. The equal pay provisions are in Part 1 of the Act. And in Part 1 of the Act, the legislature did not delegate to the Colorado Department of Labor and Employment any authority to conduct any kind of rulemaking. And so there are no rules or regulations on the equal pay portion, and there are no published cases. So since we don't have rules or regulations, the first indication we're going to get about what this all means is from the courts. And court cases take a long time to come to a conclusion. And court cases oftentimes settle. And so what we're waiting for is the case that goes through the court system that's actually tried and turns into a published opinion. And we could be waiting for a while on that. I'm aware of one case that's in very early stages against the Denver District Attorney's Office. But who knows when that'll come to a conclusion and whether it will be a public decision. While we wait for the courts to tell us what this all means, I'm watching employers really struggle with some of the concepts in the equal pay portion. So an example being the broad definition of compensation. There has to be the same compensation paid for substantially similar work. And that includes all compensation and benefits received by the employee from the employer. And that also includes other types of payments, such as sign-on and retention bonuses. That's all part of an overall compensation that's being paid to an employee. And those things are not carved out of the statute. And as I pointed out on the last slide, there is no exception for unequal pay based on market forces. So if you're offering sign-on or retention bonuses, you have to think about who else is doing substantially similar work. The other thing to keep in mind, as I mentioned, we're coming up on the 2-year anniversary of the Equal Pay for Equal Work Act. And as many of you knew when we were first talking about it in 2020, we were encouraging you to do audits. Audit your workforce, make sure that you have equal pay for substantially similar work. There's a statutory safe harbor that's provided for any kind of a good faith audit that's performed within 2 years before a lawsuit was filed. So if you took our advice 2 years ago and conducted a pay audit, you need to do it again. The safe harbor is as to liquidated damage penalties. It's not a complete safe harbor, but remember that your 2 years on your last audit may be coming to a conclusion. And then also remember that the attorney-client privilege when conducting those audits is really important. So the other part of the Equal Pay for Equal Work Act is the pay transparency provisions. And just a reminder here of what that covered, there are provisions that prohibit the employer from inquiring about the wage rate paid to an employee, but also it protects employees who want to voluntarily disclose their wage rate or talk to others about it. The pay transparency provisions also prohibit the waiver of an employee's right to disclose wage rate information or to discuss it with others. And so we're reminding you to take a look at your handbook, at your confidentiality agreements, at your invention agreements. Do those things include wage information as confidential information? And if they do, you may have a pay transparency problem. In the pay transparency realm, most of the activity I think that we've all been dealing with is around the job and promotional opportunities postings. So let me talk about that for a few minutes. What's new on the pay transparency, the job and promotional opportunities piece of it? On this one, in contrast to the equal pay part, we have rules and guidance galore. This is in Part 2 of the Act, and the legislature specifically allowed CDLE to generate rules and regulations, and they have done just that. They have provided rules, they have provided guidance. The guidance on the pay transparency posting provisions is included in information number 9 that the division publishes. By my unscientific count, I think they've already amended information number 9 at least 3 times, most recently as of September 6th of 2022. And what it seems to be happening is that as they're amending their info, kind of their guidance about how the pay transparency provisions work, they're trying to close loopholes and otherwise clarify things that employers have been asking. So in this most recent update on Info 9, we've received some additional clarifications about what type of compensation information must be posted. And they make it clear that open-ended ranges are not compliant with their rules. You're not allowed to say that this position will come with competitive benefits, or you're not allowed to say 401k, et cetera. You're supposed to describe the benefits generally, unless it's a minor perk, such as a gym membership. And the other thing I think that's interesting about this info number 9 is they are providing some clarification about who's responsible for complying with the pay transparency requirements. And they make it clear that it's the employer that's required to provide this information. And so if LinkedIn or Indeed republishes something that the employer put out there, as long as the employer included the necessary compliant information, the employer is okay. If LinkedIn or Indeed republishes without including that information, LinkedIn and Indeed don't get in trouble, and neither does the employer, because the employer did it right in the first instance. The other thing that the new info number 9 talks quite a bit about, and I think this is really a pain point for employers because it honestly doesn't make any logical sense at all, But the pay transparency provisions do require employers to post promotional opportunities. And if they're promotional opportunities for positions that can or may be performed in Colorado, they have to include all the necessary compensation and benefits information in them. And the definition of promotional opportunities, according to CDLE, is very different than what you or I might think it is. And so in info number 9, they give us some specific examples. If you are restructuring a team and you're giving one employee on that team a supervisory role, but you're not giving them a pay increase, that higher title and authority is considered to be a new position that is a promotional opportunity, and you have to post it. Entry-level roles. CDLE takes the position that an entry-level role is still a promotion for somebody in the organization. So the example they give is the entry-level role in a department that has lots of advancement opportunities. Somebody might be in a different department, and the promotional opportunity for that person is they could move to the posted department and have advancement opportunities that they didn't have otherwise. Inline promotions are also considered to be advancement opportunities. So they give this specific example. J. Doe, who is a junior accountant, is recommended for promotion to senior accountant with a salary range and the benefits described. Employees interested in this or a similar opportunity should email interest@ourcompanyhr.com. So the CDLE is actually suggesting that you're going to make this kind of a posting before you make a decision that J. Doe is actually the person that's going to go from junior accountant to senior accountant. And so I don't think that that is intuitive really for employers. And so it's really something that you need to focus on. The division does make it clear that you don't have to include J. Doe's name, but their example does actually include it. So finally, pay transparency. How is it going so far? As for enforcement, we're aware that CDLE has interns whose job is to comb through job postings and look for violations on the face of the postings. Sometimes that then results in warning or compliance assistance letters going to employers, advising them to fix their postings. I think sometimes postings that are discovered to be non-compliant can be added on to other investigatory activity that CDLE is engaging in with regard to your company. According to the division, they have fined 3 companies so far with a total assessed amount of fines of $35,000. I don't think that amount has been paid. I think there have been some settlements and other reductions in the fine, but so far 3 companies fined. Is there a wave coming? There are other states that are looking at similar pay transparency laws. Right now, there are quite a few of them that deal with providing pay transparency information if asked or as part of an interview process or before an offer is made. But there are some states that are looking at doing it as early in the process as Colorado, so basically with the job posting. Washington has a law in place that should be coming online beginning of 2023. New York City has come up with something similar, and we understand that California is also considering something. So I think it's an interesting question if we start to get, let's say, California also requiring this kind of information in job postings. Will it make it easier for Colorado employers because it's more of a norm? Multi-state national employers are going to have to do it for California, so is it such a big deal? Is it working? Well, I think it really depends on your perspective. So in August of this year, the Denver Post cited to a study that Recruitonomics prepared, finding that the Equal Pay for Equal Work Act, and specifically these pay transparency provisions, likely contributed to fewer online job postings in Colorado, especially as related to remote positions posted by national employers. So there's some information out there that this pay transparency stuff is suppressing the job market in some form or fashion here in Colorado. I think that the effectiveness of the pay transparency provisions also depends on where you are in your life cycle and job cycle. So a study that was conducted by LinkedIn suggests that younger workers believe that sharing pay information will ultimately lead to a more equitable workplace. And not surprisingly, 81% of Gen Z believes that, 75% of the millennials believe that, but only 28% of the boomers believe that. So again, not surprising, and I think it remains to be seen if this ends up being ultimately beneficial to the workforce in Colorado and to workers in Colorado from an equal pay perspective. And with that, I'm going to send it back over to Owen for a poll question.
Thanks, Barb and Sonia. That was really informative. I also really appreciate the reference to Biggie and the office in one slide. Well done, Sonia. So before we move to our next presenters, we have another poll question here, and this is on a few of the topics we have or will talk about today. From the following, which Colorado development presents the most concerns or challenges for your organization? The Equal Pay for Equal Work Act, updates to the employment discrimination laws, new limitations on restrictive covenants, or the Colorado Healthy Families and Workplaces Act? You should be able to just select the option on your screen. I'll give everyone some time to submit their responses. Looks like we still have some results coming in. Okay. So it looks like we have a pretty close split here between the Equal Pay for Equal Work Act and the Colorado Healthy Families and Workplaces Act. That's interesting and not also, I guess, not surprising. I know a lot of clients are still working to comply with those laws. And it seems like there are new changes every day. All right, well, I think we're ready for our next presenters. So next up is Chris Otley and Keith Ibanez giving an update on the wage claim investigation process, Colorado Healthy Families and Workplaces Act, commissions and bonuses, and more new whistleblower protections.
Good afternoon, everyone. My name is Chris Otley. I'm a partner here in the Denver office. I'm a member of Gen X, and I too believe that the pay transparency laws are not working.
Thank you, Chris. Really appreciate that support from my generation. My name is Keith Ibanez. I am an associate here in our L&E group at Husch Blackwell. You all might have thought you were done with legislative updates, but in a true signal that the Colorado General Assembly really loves to revamp the employment laws here in the state, we've got even more material for you. Now, first off, the Colorado legislature has taken aim in recent years at restrictive covenants. And this last General Assembly was no different. Chris, this is a pretty big part of your practice. What are the highlights of Colorado's latest bill?
Thanks, Keith. Yeah, the history of this is, I think, very important to give everyone a little bit of background, and hopefully everyone who already listened in to our update that we did about 2 months ago, where Barb and Ashley had talked about it, was able to get a little bit more in depth, but we did feel like it was necessary, particularly for the multi-state employers who are listening to us, to give you a background and to tell you the high-level points about this. We could probably lecture about this topic for about 2 hours straight. Colorado had already been one of the laws that was the most protective of the employee's ability to avoid restrictive covenants. The Colorado law had been in place for about 50 years. It provided that all covenants not to compete were void unless it fit into one of 4 exceptions. In the last 5-6 years, multiple states, particularly in the West, Arizona, Oregon, Washington, had started to change their laws with respect to restrictive covenants. And frankly, some of those states' laws came into alignment with Colorado. At the same time, there's been a lot of research done recently about the impact that covenants not to compete and other restrictive covenants have on wages. And so there has been also some horror stories out there, anecdotes. Some of you might be familiar with Jimmy John's trying to enforce a non-compete against its assistant managers. And so that's driven a lot of additional legislation, including in the state of Colorado. So the Colorado General Assembly just this past year passed a new law. It's House Bill 22-1317, and it makes Colorado even more protective. We're still not at the place where California is at. In California, non-competes are almost always going to be void unless it's for the purchase and sale of a business. In Colorado, it's just severely limited. The biggest thing that the law did is it eliminated the management personnel exception. Under the old law, the management personnel could be subject to an enforceable non-compete as long as it's within reasonable in geography in terms of protecting the duration and also protecting the employer's legitimate business interests. That exception's out no longer exists. So the way that most of the people who are listening to this call right now are going to be able to enforce a non-compete if they enter into one now with their new employee is if it is for the protection of trade secrets, it's for the purchase and sale of a business, or some training that's involved in that. The protection of trade secrets is by far going to be the biggest of all those exceptions, and that's the one that employers are going to want to work with. A key provision that is going to trip up a number of multi-state employers who are trying to enter into non-competes with a nationwide workforce is Colorado has a new rule regarding notice requirements. The notice requirements are somewhat pedantic, not particularly commonsensical, a little bit insulting to the people who sign it, but literally it is a notice saying, hey, employee, you make a lot of money. You're subject to a restrictive covenant. This restrictive covenant is contained in another document and you need to sign it. And it's frankly, it's not something that you really should be using, should be avoiding.
I find this a curious requirement because like you meant or alluded to, it is somewhat insulting, or it could be interpreted that way, because you're essentially telling the employee or individual entering this restrictive covenant, listen, you just signed an agreement and we don't trust you to have read your agreement or to understand what it says. So here's a separate document telling you exactly what's in there. Is that kind of the vibe?
That's not only is that the vibe, it absolutely voids agreements without that notice. Now, to be clear, if it only applies to agreements that are entered into after the effective date of the statute, which is August 10, 2022. So if you already have covenants not to compete and other restrictive covenants with your employees, that's fine. Anything entered basically from last month forward now needs to comply with this law. You must provide that notice. I assure you that's going to be the first question I ask every single employer when they come to and ask me about whether the covenant not to compete is enforceable. There's also, again, I could talk about this for a while, but the reason why I referenced the statutory penalties of $5,000, if an employer seeks to enforce a non-compete that is unenforceable, they will get fined up to the $5,000, and they can also have their attorney's fees of the employee assessed against them. One good part of the law, so to show you that I'm balanced, one good part of the law is it says even for any of the covenants not to compete covered by the trade secrets exception, employees must be making above a certain wage. It's $101,250 right now. It's going to continue to go up. The Division of Labor will continually put that move that forward each year. It's only 60% of that amount if you're trying to have a covenant regarding non-solicitation of customers or clients. Okay, and then finally, a really important thing, particularly for the multi-state employers, Colorado law applies. Colorado courts are going to be the place where the disputes are tried. This is an issue that comes up in multiple cases. It's very frequent. I'll be honest with you. I think, frankly, this area of the law just syncs up with kind of where most courts were ruling. If you have a Colorado-based employee performing services in the state of Colorado, you should assume the Colorado law applies.
Yeah. So go back into your agreements, check those choice of law provisions. If it's designates a state other than Colorado and you're entering into an agreement with a Colorado employee, you're going to want to revise that.
Yep. All right. Keith is going to take on Healthy Families Workplaces Act, otherwise known as HIFWA, which is a great acronym to describe something that is just as clear as mud. Go ahead.
So I know the focus of our segment is recent legislative developments, and HIFWA may be familiar ground for many of you since, it was enacted back in the early months of the pandemic in, I think, July of 2020, but it only just became effective in January of this year. So I felt it'd be good to refresh it, make sure we're all on the same page when it comes to HIFWA compliance. Now, HIFWA requires that employers provide 48 hours of paid sick leave to employees. And the aim of this law is to provide paid sick leave benefits to all workers. Sometimes PTO benefits can miss workers who are part-time or hourly, and this law kind of fills in those cracks. Now, the law also provides what's known as public health emergency leave. And you can figure out where the genesis of that was since this law was enacted in the early months of COVID. So what this does is it provides employees effective upon their hire date with at least or up to 80 hours of public health emergency leave. Now, part-time employees or hourly employees who don't work a full-time schedule, their calculation will be a little different. It'll either be an average of their last 2 weeks of work or their next 2 weeks of work. But in any event, it provides this leave and it allows employees to use it if they have to self-isolate, or they've been diagnosed because of a communicable disease, or they have to go get treatment for a communicable disease tied to the public health emergency, or they have to care for a family member who's self-isolating or been diagnosed with a communicable disease tied to the public health emergency.
Keith, do employees get 80-hour top-off each year?
No, this is not a calendar top-off. That's a great question.
Thank you. Thank you.
It's one a lot of people are wondering. It's not a calendar top-off, so it's not an 80-hour freebie each year. It's a one-time deal, and you supplement it during that public health emergency. Now, we're still in a public health emergency right now, despite President Biden's proclamation last week, and I believe 60 Minutes, that the pandemic was over. According to at least the CDLE, we're in a public health emergency until at least November 10 of this year. The likelihood of that being extended seems pretty high, but stay tuned.
I'm going to throw one at you. We'll see. What percentage of employers understand the public health emergency top-off?
I don't want to give a hard percentage, but I would say probably less than half.
Correct.
Yeah. And I don't mean to besmirch any of our employers out there.
The only ones who understand it have called us.
Yeah.
All right. I'll take on the next topic, which is going to be the wage theft, employee misclassification enforcement. The slides we prepared on this already has some really good information, and I'm not going to go bullet point by bullet point. The point here is that I think in probably the last 6 or 7 years, the Colorado General Assembly has considered a wage theft law almost every single year. And I think they've passed 2 or 3 of them even before this one was passed this most recent year. You might ask why. Well, I was talking with a plaintiff's attorney when we were doing kind of a similar presentation not that long ago, and she cited the statistic to me, which may be apocryphal, but it was something along the lines of, this is the most common violation of the law in the entire country, that employers are not paying their employees the wages they are due. If you are listening to Husch Blackwell's Labor and Employment Seminar, you don't fit into that category. You are probably going to be a pretty good employer who's doing its best to pay your employees what they have earned. There are sometimes some question marks that are open, for example, around bonuses, whether they're discretionary or mandatory, or about commissions, particularly which commission salesperson might get credit for a particular sale. But for the most part, you're not the kind of employer that's going to hire a day laborer and then at the end of that day say, well, I know I promised you I'd pay you 20 bucks an hour, but I'm now only going to pay you 15 bucks an hour. But the law is geared at those bad faith employers. And so what the General Assembly has done is they just keep ratcheting up the pressure on employers over and over again. And it can have an impact on the good faith employers as well. For those of you who have talked to me about wage and hour law, you know that you probably heard me say, it's a black and white issue. You're either in compliance or you're not. And if you're out of compliance, it can get really expensive really fast. So what this new law did is first of all, it created a new enforcement mechanism with the Division of Labor that's going to look at all sorts of issues around wage theft. So it gave them a little bit more muscle to go after those bad faith employers. It requires employers, to provide 10 days of notice to an employee if they think that the employee has taken any sort of company property. That's always been an exception to the deductions part of the wage law. And it also talks about what employers must do if they haven't paid full wages within 14 days of receiving a demand. Penalties now are 2 times the amount that are owed, or up to 3 times the amount that are owed if it's a willful violation.
The 10-day notice is an interesting wrinkle because I think it will force employers to kind of do a quick accounting of any assets that they've given an employee and hasn't been returned. So, you know, a phone that's out there missing, maybe some high value equipment, a laptop, things like that. Employers now have the small window of time, these 10 days, to figure out, has that been returned? They need to, if not, need to send out a written notice to the employee identifying those items, what their values are, and giving them notice that it's going to be deducted from their wages. And then if those items are returned, then the employer has to pay back what it's deducted within 14 days.
That's exactly right. That's right. Yeah. You gave a much better explanation than I did.
This is teamwork here.
It also creates yet another cause of action for employees to file a lawsuit. This was already the law. Employees complaining about their wages were already protected from wrongful termination. Again, any employer who's talked with me in the past knows that I basically say that for the purposes of litigation, at-will employment still survives. For the purposes of day-to-day employment advice and me giving you advice on how to manage a situation, at-will employment is dead. It's dead as a doorknob. If you don't have a legitimate reason for why you're letting the employee go, and you can't articulate it as of the time the employee is let go, you might as well assume that you're going to get thrown out with some wrongful termination claim. So this creates that, which includes attorney's fees, back pay, reinstatement, things like that. And pretty much every new law that we see passed now has these anti-retaliation provisions. Speaking of commissions and bonuses, Keith?
Yeah, so the CDLE issued an updated info number 17 3 months ago, just to clarify how commission and bonus payments should be treated. I think the overriding or overarching point that they're trying to make is that any commission or bonus that's been earned and determinable, those are the 2 key buzzwords here, those are treated as wages and should be paid out even if the employee departs their employment. Now, a lot of times, commissions and bonuses are paid out later. Say, for example, the employer issues an announcement to its workforce that any employee that meets a Q4 production quota will earn a bonus that's paid out at the end of March. Now, an employee meets that production quota at the end of Q4, but they leave their employment, say, in February before that March payout is issued. A lot of employers will think, hey, that's money we get to claw back. They're no longer here to collect their commission or to collect their bonus that they've earned. The CDLE says not so fast. That has to be paid, and employers need to be aware of those outstanding commissions and bonuses at the time of separation. And any policies or agreements otherwise that would presume to waive or obviate those obligations are void and unenforceable. You can't have a policy that says you have to be here to collect your earned bonus. Once the employee separates, that needs to be paid out. Now, a truly discretionary bonus does not fall into that category, but just slapping on this is a discretionary bonus, but laying out the terms or parameters and criteria that need to be met, that is unlikely to be treated as a discretionary bonus. But if it's a true, hey, you did a great job this year, here's a couple extra bucks, that's a true discretionary bonus, and you don't need to issue that upon separation to an employee.
Hey, Keith, I have a question. What if part of that job for the salesperson who made the sale in Q4 is to make sure it gets collected in Q1, and that's the reason why the payment's not until the end of March? Is there an exception for that?
That is an interesting question. So if they've already made that sale and they just need to collect it or it needs to be paid, if they don't do it, but say the client or outside vendor does pay it eventually after they've gone, they still get to collect their commission or bonus on that. That's not a truly contingent criterion for the payment of their commission because they've done the hard work or they've done the heavy lifting to earn that money. And most of the time, that's not going to be on, say, a commission salesperson to follow up and make sure that all of those payments are made. So that's another one where the info number 17 really clarifies for employers how to treat these commissions and bonuses.
Yeah, I think that's exactly right. And the comments I used to make when I was advising on these issues was that wage and hour law was basically just breach of contract law with enhanced penalties. One of the things we've learned with the elimination of use it or lose it vacation, and now also with this, which is very similar, I think they even cite the Supreme Court case that dealt with use it or lose it vacation. There are now prohibited activities, regardless of what's in your agreement with your employees, and certainly what would be in the policies with the employees. All right, we're going to talk a little bit about whistleblower protections. The first one, I believe, that we've already had some discussion about. Keith?
Yeah, Sonia mentioned this earlier, but I'm going to expand on it, much like how this amendment expanded on the initial public health emergency whistleblower. Yeah, thought about that one just now. So. Right. So this Senate Bill 22097 expands the emergency whistleblower protections and no longer ties it to the public health emergency. Kind of makes sense since we're coming out of a public health emergency now, but I think the legislature likes what this bill has done in terms of protecting whistleblowers and making sure that safe workplaces are prioritized and can be investigated appropriately without fear of reprisal. And that's exactly what this does. It protects workers quite broadly who raise a good faith, reasonable concern about health or safety. It can be either a violation of a public health and safety rule, any mask mandates that are required of an employer, any OSHA requirements, guidelines like that. If they see something, this is very much if you see something, say something, and then we're going to protect you. Employers can't retaliate against their employees for raising such concerns. And
hey, Keith, I have a question.
Sure.
Didn't OSHA and the NLRA already provide protections to employees for raising legitimate workplace concerns about safety?
They sure did, but you know.
Oh, that's interesting. So we have another law that deals with the exact same topic.
We love to overlap here.
Great.
With our lawmakers. So just because there's one bill out there that does that doesn't mean there can't be more. and that's what's happening here. And you might be wondering whether you're covered under this. So an employer or how the bill terms it is a principal. So a principal can mean an employer as defined under a Colorado wage law, or any entity that contracts with 5 or more independent contractors in the state of Colorado, a state or local government organization, although the federal government is, of course, exempted from this.
That's right. Let me ask you the high stakes question, which is how does an employer know when it's a good faith, reasonable concern about health or safety? Because obviously if it's bad faith or it's an unreasonable concern, that isn't entitled to protection under the law.
That's a great question. That they're going to have to know what their practices are and understand, is this coming from a good place? Have we done everything properly? But I think it's best to err on the side of caution, because raising or retaliating against bad faith complaints can be a costly endeavor.
Yeah. So I think the one thing I'd add is this is very analogous to a lot of employers put in their policies that say we will never retaliate against a good faith allegation of discrimination or retaliation. But we all know there's going to be bad faith allegations, and employees, subject to some sort of performance review, and they don't like the fact that they're about to not get a raise in this particular year. And so then they start making a false allegation, or at least a trumped up allegation of, in this case, it could be a safety issue. It could also be for retaliation. The one thing every employer needs to really ask themselves is, do you feel like you're going to be able to convince a third party neutral that this was a bad faith allegation that was made? And if you can't convince a neutral, because you're not going to be the judge, it's going to be a judge or a jury or an arbitrator that's going to decide this. If you don't think that you can make that determination, you need to assume that it's going to be good faith. So my word of caution to all employers is relying upon that exception is a high risk move. And I think that at least some of us have as a high level of risk tolerance of any defense employment attorneys out there. and I'll put myself into that category, I would really not rely upon this good faith, reasonable concern unless you know you can establish it is legitimate.
Yeah, Major, it's a trap, Commander Akbar from Star Wars
Yes.
Episode 4.
Can you use the voice?
Yeah, I'm so bad at it. I wish I could.
It's a trap!
Really, that's really good. Wish I had that talent. But the public health emergency whistleblower law isn't the only whistleblower protection law out there. The Colorado False Claims Act was recently enacted, and it's very much patterned after the Federal False Claims Act. And I think we're going to see a lot of litigation born out of this one. What it does is it creates a general civil cause of action for entities that make a false or fraudulent claim to the state or political subdivision. And what this is born out of is the influx of COVID-19 relief funds over the last few years. If any of you have been reading the paper, watching the news, I think there's been a lot of investigative journalism kind of highlighting a lot of the fraud in terms of application or utilization of relief funds. And this bill is meant to combat that.
That's right. So if anyone's familiar with the Federal False Claims Act, for the attorneys, you'll recognize the term qui tam litigation. It's been an incredibly lucrative program for the federal government to recover funds that have been allocated by the federal government to private entities. And it's basically a whistleblower statute. It becomes a bounty for the whistleblowers to be able to report that somehow or another federal funds have been misused. The state of Colorado did not have the equivalent. Many states did. California, not surprisingly. I think New York has a really robust one as well. Colorado had not had this statute. Traditionally, if a a state contractor in the state of Colorado had somehow or another misused the funds, it was up to the Attorney General to enforce that state contract. That misuse of funds, by the way, could be very technical or could be very substantive. I think we know there's a lot of allegations, as Keith alleged, or Keith just pointed out, that said that you did have a lot of people who were frankly just misusing those funds. Those whistleblowers are able to bring a lawsuit on behalf of the federal government. Colorado is now able to do the exact same thing. So what this becomes is a really robust and frankly very dangerous enforcement mechanism for anyone who's receiving state funds. And that includes, by the way, some municipalities as well. So this is not restricted to just the state government. So if you are on this webinar right now and your company has some sort of state contracts, you should be aware that you would be subject to the potential of having a whistleblower, someone within your workforce, filing a lawsuit on behalf of the state of Colorado. The Attorney General, that person then becomes what's called the relator. The relator then works with the Attorney General's office to then pursue that claim. And there's a lot of different variations, and that's outside the scope of what I want to bring up. But the end result of that litigation is going to be substantial penalties, tens of thousands of dollars, plus up to 30% of the recovery that's available. So even a bad faith whistleblower, so in other words, someone who is actually participating in the fraud, they could be entitled to 15%. The only time I thought about being a plaintiff's attorney in the last 20 years is when I was defending one of these qui tam litigations. Because let me tell you.
Why is that, Chris?
Because there's a lot of money involved in these cases.
And very little work for the money that is involved.
That's exactly right. The plaintiff's attorneys that get to take the back seat and watch the Attorney General take off with that.
Yeah.
And so these things can be really substantive. On the employment side, which is more germane to what we're trying to talk about here, you also need to understand that the retaliation provision under this bill, the Colorado False Claims Act bill, is the broadest retaliation provision I've ever seen. It literally covers anything affecting the terms and conditions of employment, from things that are as serious as obviously wrongful termination and retaliation and harassment, all the way down to things like blacklisting and any other terms and conditions of employment. You know, what happens if somebody puts your stapler in a Jell-O mold? Is that going to be considered harassment, all because you filed a claim against that individual employee? They also need to
What if I give you a nasty look? Does that count as retaliation?
Well,
it might.
I've seen it litigated, Keith. I've seen it litigated.
Yeah, this is quite broad, so tread lightly out there.
Yeah, exactly. So very high stakes if you have the claims brought against you, very high stakes in terms of the protections for employees. And then an issue that I think is really significant, and this is something that we're going to see a lot more of in coming years, I assure you. if you have a standard confidentiality provision with your employees in your handbook, in a policy, even better if it's in a standalone agreement that Shauna Ritz drafted for you, if you have that confidentiality provision, it cannot prevent this employee from sharing your confidential information, the business's confidential information, with either their attorneys or with the Attorney General's office. I think most of us probably know that if you have a whistleblower who has really bad information, for example, tobacco litigation is kind of the rubric a lot of us will consider this about, they will say that that individual employee is able to share that with the government. Now it's explicit under this statute that there is no confidential information that cannot be shared with a key TAM litigation attorney here in the state of Colorado.
Right. So if you're an employer trying to enforce the terms of your NDA or a confidentiality agreement or an employment contract with a confidentiality provision, under a circumstance like this, the bill allows for treble recovery of attorney's fees and costs if you're wrong. So
yeah.
Don't be wrong.
That's for darn sure. Yeah. So I would expect, going on to our, I believe our final slide, we put some of the numbers up there so you have a better sense of what's going to happen. Again, the Attorney General, the local prosecutor can bring these. Individuals do get subject to these penalties of $11,000 to $23,000. By the way, that syncs up perfectly with the federal law. It's a really powerful tool for the state. And so as a matter of public policy, this is probably a pretty darn good law. What's really the issue is how is this going to play out, particularly for these employees who are now going to see an opportunity and they might want to exploit that opportunity. It'll be a little bit of the tail wagging the dog. As I said, really, really good attorneys have focused their careers on these kinds of laws. And the reason is because there is substantial payouts at the back end of them.
Right. That's all from us. We're going to go back to Owen, who I believe has another poll question for everybody.
Thanks all.
Thanks, Keith and Chris. I really enjoyed that lively back and forth. Yes, so now on to our last poll question for today, which leads nicely into our final segment. When was the last time your organization updated its employee handbook? Please be honest here. The first option is 2022, 2020 or 2021, before 2020, or finally, our organization does not have an employee handbook. I'll give everybody a few seconds to submit their responses. All right, let's see the responses. Good, that's great to see that a majority of you have updated your handbooks this year, so that's great. Okay, well finally here, Shauna is going to discuss updating your handbook and policies in light of the recent employment law changes in Colorado, a lot of which we've talked about today. Take it away, Shauna.
Great. Thank you so much, Owen. My name is Shauna Ritz, and I'm a senior associate here at Husch Blackwell. And today I'm going to be talking to you about employee handbooks. As an employment lawyer, one of the most common questions we receive is, should I have an employee handbook? As you can tell from the presentations that we've already had today, law in Colorado is consistently changing and it is complicated. So I often recommend, regardless of size, all employers should have a handbook and they should update it on an annual basis. I recommend at least having the requirements, state and federal requirements in a handbook. And of course, handbooks can have more beyond what's required by law, but at a minimum to include those basics. For this presentation, I will be covering handbooks as they've been impacted by recent changes in Colorado law, or what we anticipate will impact your handbook policies in the near future. So the first area is the Equal Employment Opportunity Provision. And this is based on a little bit older law. So an EEO provision should prohibit discrimination based on all protected classes, and that should be federal and Colorado law. Colorado law is a little bit more expansive than federal law as far as what classes are protected. In September of 2021, the Colorado Anti-Discrimination Act was amended to include gender expression and gender identity as protected classes. And this was as a result of the Supreme Court decision in Bostock versus Clayton County. So now gender expression is included, which means an individual's way of reflecting and expressing their gender to the outside world. And this is typically demonstrated through appearance, dress, and behavior. And gender identity means an individual's sense of their gender, which may or may not correspond with their sex assigned at birth. So here is a sample EEO provision that includes the protected classes under Colorado law and federal law. You'll see we've got race, creed, color, religion, sex, including pregnancy. And now under sexual orientation, that includes transgender, gender identity, and gender expression. So this is something that we commonly catch when reviewing handbooks. You just want to make sure that you are checking that you've included all protected classes in your EEO statement. So the next area that we've started to receive a lot of questions around is how handbooks can be updated to include diversity, equity, and inclusivity. Here are some suggestions of things that you can do to incorporate those into your handbook. You can use gender inclusive language, and this could be using the pronouns they, them, or their, or you can use a consistent term such as employee, teammate, however you refer to your employees internally. You can review and assess your employee for equity. So an example is, what kind of holidays are recognized by the company? Are they based on all sorts of religions or certain religions? And you can also consider how diversity, equity, inclusivity are a part of your company. So whether it's part of your mission statement, core values, or if you have your own diversity statement, that's something that you want to include in your handbook. So next, we're going to talk about the different types of paid leave. So this has been a real hot topic over the last year. There are several different kinds of paid leave required by state and federal law. And you'll see those listed here on the slide. Today, we're going to focus on paid sick leave and vacation leave under Colorado law, and then the different kinds of policies that incorporate sick and vacation time. So the big question is, what type of paid leave policy should you have? And this is complicated. The intersection between all of the different kinds of leave, vacation, paid sick leave, PTO, and how they work is complicated. In general, there are 4 different options that we usually include in policies. There's paid sick leave only, and that usually tracks with the HIFWA. Paid sick leave with a separate vacation policy, and then again, the vacation would track with Colorado requirements. Paid time off, which is going to be one policy that incorporates paid sick leave and vacation, or a flexible time off policy. So the first option is paid sick leave only. Now that all employers of every size are required to have paid sick leave, at a minimum, you should have a paid sick leave policy. As you've heard today, HIFWA can be very complicated. And so I've included here, and you probably have already heard some references to what are called info sheets. So the Colorado Department of Labor and Employment has produced what it calls interpretive notice and formal opinions, where they provide additional detail and guidance on different topics. Included here are the specific info sheets for HIFWA. I recommend when you are creating a sick leave policy that you pull these up and read them and have them with you. And also check consistently. We are seeing updated info sheets come out consistently. So it's something you definitely want to continue to watch. Included is the website where you'll find those info sheets. So what should you include in your paid sick leave policy? So the policy should specify whether the regular, or it's also called accrued paid sick leave, will accrue over time or be granted at the beginning of the benefit period, or for a new employee that would be at the time of hire. As you've already heard today, the accrual rate for a non-exempt employee is 1 hour for every 30 hours, and non-exempt employees accrue leave as if they worked 40 hours in a week. And so that's something you will want to detail in your policy, how time sick leave will be accrued. You should also identify the reasons that qualify for regular paid sick leave, and then also detail what qualifies as public health emergency leave. So keep in mind the conditions that qualify for regular accrued sick leave are different than those that accrue for paid health emergency leave. However, there can be some crossover on those two types of leave. And so if there is crossover, you'll want to remember and include in your policy that employees are allowed to use that public health emergency leave first. We often get asked, when will public health emergency leave be over for COVID-19? Currently, that is November 10th, 2022, if it is not extended again. Another question we often receive is monkeypox covered by the public health leave under HFWA? The CDLE has come out and said no, that they don't think that monkeypox is highly fatal enough to classify it as a public health emergency. So at this time, HFWA does not apply for monkeypox. And then a policy can also request that reasonable documentation be provided if an employee is going to be out for more than 4 consecutive days. This only applies to the accrued paid sick leave and not the public health emergency leave, for which you cannot require any documentation. So the next paid leave option would be a combination of paid sick leave and vacation leave. So just to quickly cover what vacation leave entitles in Colorado, you're not required to provide vacation leave, but if you do, there are rules around that. So if you offer vacation, it must be paid out at separation if it's been earned, regardless of any written policy to the contrary. So you can no longer have any kind of use it or lose it policies. In January 2022, the wage protection rules provided some additional information that vacation pay is considered pay that is used at an employee's discretion. So this is different than other types of leave that we're not covering today that have qualifiers, such as caretaking or bereavement or a public holiday. Anything that is at an employee's discretion will be considered a vacation. And then the CDLE has also provided some great guidelines around vacation pay. And so you can find that at info sheet number 14. So what should you include in your employee handbook in regards to vacation? So your policies should set out how much is being offered and that you cannot have any requirements that vacation pay will be limited by performance, at termination, resignation, or any other kind of event that would forfeit vacation that has already been earned. To be paid at separation, vacation must be determinable. So you're going to want to include in your policies how vacation accrues and if there are any caps on that. So you can cap vacation pay at 1 year's worth of vacation pay, so nothing less than that. So if you are going to cap, you want to be explicit. You can include things such as once you hit this cap, you will not accrue any additional vacation time until you've used what has already been earned. And that's a way to control how much vacation time is available and would have to be paid out at separation. Oh, and also keep in mind floating holidays, if you're allowed to elect when you want to use those floating holidays, are also considered vacation. So the third option is paid time off. And this is when you have one policy that will cover vacation pay and sick pay. Because vacation pay is usable without a qualifying event, it can be in several different kinds of forms, and it's what you're really looking for is whether or not the time off is at the discretion of the employee. And so you can see this is quotes from the law about paid leave can be vacation leave. It can have different names like personal days, paid time off, annual leave, floating holidays. All of that's considered vacation. So prior to these recent changes in rules in January, there was a gray area of whether paid time off had to be paid as a wage at the time of separation. And so now it's clear paid time off is the same as vacation. So similar paid sick leave under the Healthy Family and Workplaces Act allows a PTO policy to include paid sick time if that policy provides the time off that is required by HFWA. So what you want to make sure is that you have at least the same amount of hours with pay sufficient to satisfy the minimum requirements of HFWA. That the paid time off can be used for all the same reasons that HFWA can be used for, and there's not a narrow set of purposes, and under the same conditions. And so what we recommend when you're doing a PTO policy and you're rolling in vacation time and paid sick time, you will still want to be explicit of accrued paid sick time can be used for these conditions. Public health emergency sick leave can be used for these conditions. And so that makes it very clear that the paid time off is being used for what is required by HFWA, and then also can be used for vacation time. So here is some sample PTO language that you can use. An employer provides X number of paid days each year. This includes days for vacation, mental wellness, family events, emergencies. And then this is where we're explicit and say it also includes 48 hours of paid sick leave per calendar year. So in your PTO policy, you are again going to want to detail how PTO accrues and if there are any caps on PTO. Again, we typically recommend capping the PTO on an annual amount because, like vacation, PTO does need to be paid out at separation. One of the things to also keep in mind is if you allot a certain amount of PTO that meets the requirements of HFWA and someone elects to use all of their time for vacation as opposed to paid sick leave reasons, you're not required to offer any additional sick leave because you've already met the minimum and the employee has chosen how they wanted to use that PTO policy. And so again, here you'll want to detail how HFWA works and that that's part of the PTO policy. So this fourth option is flexible time off. And flexible time off is typically an unlimited PTO policy. So this is actually something that we've seen a lot of employers moving towards this year with these new requirements around paying vacation or sick time at the time of termination. So info sheet 14 provides that if PTO is unlimited, then it is not payable upon separation because the amount is not determinable. So one thing you have to be careful with is if you are telling employees that they have an unlimited policy, that it truly means that you're not somehow limiting them to a certain amount of weeks or continually denying requests for time off, because then it won't be viewed as a truly unlimited policy. And again, you'll want to include that the FTO policy covers paid sick time off. So although FTO policies are unlimited, you can still have requirements and limitations around when FTO can be used. So some suggestions would be you need to have a certain amount of advance notice. You need approval by management. FTO will be granted based on business needs, whether other people have already requested those dates. But what you have to be careful about is those limitations cannot apply to using FTO for paid sick leave. So again, if you qualify for paid sick leave for a reason under HFWA, you have to be able to take that. And so that's something that you want to be careful of distinguishing. And then with both FTO and PTO policies, you'll want to require document the reasons for leave. So HIFWA does require that employers maintain documentation of paid sick leave for 2 years. And so what we often recommend is if you have some kind of form that employees fill out when they request leave, that they indicate whether it's sick leave, under accrued sick leave, or public health emergency, or other. So that would be your vacation bucket. And then that's a way that you can track whether or not you have provided any requested and owed paid sick leave. So another big question we get is, how do you convert from one policy to another? So again, because we see a lot of employers going from PTO policies to these FTO policies, you have to make sure that whatever your current policy is, that any earned indeterminable vacation or paid time off, whatever it's called, is paid out before you switch over to a policy, a new policy. So usually it makes sense to make these kind of switches at the end of a policy year. And you can do it a couple different ways. You can let employees know whatever vacation and PTO you have left at the end of the year will be paid out. Or in your new policy, if it's an FTO policy, you can require that all earned paid time off or vacation time be used before they switch over to the FTO program. And so that helps, an employer's liability by requiring that paid sick time to be used up, and ensures that employees are paid all wages that are earned indeterminable. So next, and this is kind of the big topic of the time, this time, is how does FAMLI apply, and what kind of policies should you as an employer be putting in place? So right now, the CDLE has come out and said for fall of 2022, employers should start focusing on policies and language around how employee premiums will be deducted. And then moving forward, they suggest beginning in fall of 2023. However, I think starting now is great because it is going to be complicated and a process. Start considering what will your policies look like about family benefits that will be provided to employees. So this is an example of what an employee paycheck will look like with premium deductions. So I know we cover this, but just as a reminder, because you will want to have this in your policy and be very explicit, let employees know that 0.45% of their pay will be deducted as their employee portion of the premium, that this deduction will start January 1st, 2023. And it's also important to explain that the way the deduction for the premium is calculated, it does not include certain other deductions from their paycheck. And so you can see this example in the pay stub of what is not included in that premium calculation. And then also know employers do have the option to pay some or all of the employee's portion of the premium. So if that's something that you elect to do, you would just want your policies to reflect that. So I also think it's time to start preparing for your family benefits policy, although you don't necessarily need to roll that out. What we have seen some employers do at this point is put in their handbooks a general overview of what family benefits will cover. So 12 to 16 weeks of paid time off, some of that general benefit language with the caveat that this will begin January 1st of 2024. So if you're updating your handbook, it may be a good time to go ahead and throw that in there, and you'll be ready to go for when those benefits go into place. Another thing that you'll want to do is start thinking about how do all your different policies interact with each other. So, we've talked a little bit about this today. There is crossover between the FMLA, ADA, HIFWA, PTO, workers' comp, short-term disability, and long-term disability. So it can get very complicated of what is and isn't covered under these different kinds of benefits. So you want to review all of your different policies to make sure that they're consistent and you are covering everything that needs to be covered. So as a note, remember that as an employer, you cannot require employees to exhaust any kind of accrued leave. sick leave or other paid time leave off while they're receiving family benefits. So we know this with the state plan, if you choose to go with the state plan, the maximum benefit is going to be $1,100 a week with a max annual benefit of $13,200. So depending on what your workforce looks like, if you have employees whose salaries are significantly higher than that, you have a couple options where you can choose to do a private plan that is set up to meet or exceed these requirements. The CDLE has said, even though you cannot require employees to use any kind of paid vacation or sick time, employees and employers can explore a mutual beneficial option for making an employee whole. So that could look like a policy that allows employees to elect to use PTO or other accrued time to cover that gap, or something like that. That gives you flexibility to use what you have in place. You just cannot require it. Oh, and one other thing that I wanted to note, because I think this might be a big change for many policies, if you do have an FMLA policy that does require the use of PTO as part of FMLA, the CDLE has advised that those kinds of policies will need to be revised because that does conflict with the family law requirements. So again, this is complicated and things are constantly changing. So what resources are there for you that you can rely on? The CDLE has said that they will be creating some visual tools to help employers understand the intersection of the different laws. They should be releasing a matrix sometime in 2023. There will also be coordination of benefit rules that will be distributed. And then also one thing that I have found really helpful is on the CDLE's website, and it's under the webinars they've had for employers. They have a FAQ section. I think it's 12 pages of questions received during different webinars. And this is just one example that I thought was really helpful to understand the interplay of these different kinds of benefits and policies that you want to think through. So the example is, if an employer is already providing short-term and long-term disability that provides 50 to 60% of the max benefit of wages, would that work instead of using FAMLI? So the answer is it's unlikely to work, and that's because what's required by FAMLI coverage is more broad than what short-term and long-term disability typically cover. So one example is safe leave for domestic violence. However, if the need for the leave does qualify for one of your benefits, you can use what you already have in place. If it meets or exceeds those requirements, you will just need to figure out how what is not covered by what you already have in place will be covered. So, likely if you're using existing plans, you would have some kind of private plan tailored to cover what is not already covered. So I would look at those FAQs. It's a great tool that you can use. So final thoughts, Colorado employment law is constantly changing. We recommend watching the CDLE's website, watching those info sheets. They really do provide detailed information that will help you with your policies. FAMLI is still in progress. There's going to be a lot of changes there. Again, watch their website. They have an employer's toolkit that you can use there, webinars, FAQs. It's a great resource for employers. Review your handbooks and policies on an annual basis. And keep in mind how the laws overact with each other and impact related policies. So with that, I'd like to turn it back over to Owen to close us out for the day.
Thanks so much, Shauna, and thank you all for joining us today. We know it was a lot of information, but we hope it was helpful to you and your organization. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Finally, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your organization's needs. This concludes our webinar. Thank you.